With us today is the China Tribunal Chair, Sir Geoffrey Nice, QC, and Counsel to the China Tribunal, Mr. Hamid Sabi. Professor Sir Geoffrey Nice has been a barrister since 1971 and served as a part-time judge in England between 1984 and 2018. Between 1998 and 2006, he led the prosecution of Slobodan Milosevic, former president of Serbia, at the UN's International Criminal Tribunal for the former Yugoslavia. Since 2007, he has advised and represented at the International Criminal Court and elsewhere states, applicants and victims concerning several internal and international armed conflicts. Sir Geoffrey was Gresham Professor of Law from 2012 to 2016. He was knighted in 2007 for his services to international criminal justice. Hamid Sabi is a London-based lawyer with an international practice in human rights, arbitration and litigation. He acted as counsel and reporter to the Iran Tribunal, which was an independent people's tribunal investigating mass killings of political prisoners by the Islamic Republic of Iran in the 1980s. Sir Nice and Mr. Sabi, thank you very much for joining us today. The floor is yours.
Well, thank you, Elke, and to the, I think, 22 participants. Hello, I suppose. It's unfortunate that I can't actually see you on a screen, but apparently I can't. So I just simply know that you're there. And in due course, I'll look forward to receiving questions and hoping to be able to answer them. I'll speak for a little bit. Hamid will follow me, and then I'll follow Hamid, and then we'll have Q&A. Before I say anything else, not only must I thank Elke for being the host of this event, but I must make it quite clear that were we in the same room, we would be sitting at a separate table from Elke to make absolutely clear that we are independent of the organization that, it is true, her organization, that asked us to do the job of this People's Tribunal. Completely independent of all other interests. We have no interest as tribunal members in the People's Republic of China. I have no idea what the religions of my fellow tribunal members was or their politics. We are just citizens, and we came together in order to ask and answer questions. Having asked and answered them, we're largely a spent force. We're only too happy to come and talk to an occasion like this, but on a very limited basis. And I'll come back to that in a second. I can't tell if I could look at you, and there are now 26 of you. I might be able to tell whether your faces are puzzled at the use of the word People's Tribunal, or if you look bored at the prospect of my telling you what they are. So I'll sort of halve that uncertainty and tell you a bit about what they are, just in case some of you have no experience of them. First of all, People's Tribunals are no panacea, and nor are they to be used too often. They have limited function, and that function is best and only really when there's been left a gap by a national level, gap left by a national or an international body, or even by some of the large NGOs in asking and answering questions that the world citizen or the national citizen want asked and answered. They're gaps that have been left usually for political reasons, either of the parties concerned, or because the country that might ask, the international body that might ask the question, is timid of doing so, given the power of the countries involved. And so it was that after the Second World War, the first in time of these significant tribunals was the tribunal set up by Lord Russell, a philosopher, looking at, but only at, the alleged criminality of the United States of America into Vietnam. Now, that tribunal, flawed in many ways, not just for the reason that it only looked at one side of the conflict, is nevertheless the only evidence-based analysis looking at that issue. And that's quite important, because in decades or centuries to come, if people say, well, what about crimes committed in the Vietnam War? There'll be a large number of books, journalism, television programs, etc., etc., etc. But there's probably only this one evidence-based legal analysis. And it's worth having a look at it, or looking at some bits of it, to understand the underlying philosophy of people's tribunals. And when we come to the China tribunal that I chaired, you'll find some references in the first few pages to what another left-wing philosopher, Jean-Paul Sartre, gave by way of explanation for the potential use of people's tribunals. Finding both their power and their usefulness in their complete lack of power, and of course their lack of affiliation, as it should be, to any political movement or opinion or anything else. And then the second one, and I'll pass swiftly and now forward, the second one of great importance, although dealing with an earlier event, is the so-called Comfort Women Tribunal, which you can find under that name on the internet, which reported in 2000, much later than the Russell Tribunal, into the much earlier events in the Second World War of the sexual enslavement of women from many countries to serve the sexual appetites of the Japanese soldiery. And those terrible events, which you will find hard to read about if you turn to that judgment, were not touched upon in the Tokyo war crimes trials. And of course, in those trials, it was politically expedient for the then emperor to be kept out of the dock altogether by General MacArthur, who established the tribunals, which you'll find if you go to the Comfort Women Tribunal, that brought some solace to the women who were still surviving, so whatever it was, 55 years afterwards, and who had had the courage to give an account of their suffering, that the emperor himself is found to be culpable. So that was another gap filled, another historical record set, and some benefit brought, and we may turn to other benefits of that tribunal. So that's the background. And before I hand over to Hamid to tell us about the practical aspects of the tribunal we established a few years ago now for forced organ harvesting, just a quick look forward. What use can be made of them? What use is made of them? Or do they have any effect? Well, of course, they can't send people to prison or anything like that. They can't apply economic sanctions. But what they can do is provide a fact, because the tribunal will have analyzed the evidence, applied the law, and found facts to a very high level, in the case of the China Tribunal, beyond reasonable doubt, things that happened beyond reasonable doubt, whether crimes were committed. That fact is then placed into the public domain. The tribunal would be overreaching itself if it said, and we think that airlines should do this, and universities should do that, and schools should not do this, and businesses and so on. That would be complete overreach. But we can say, and we did say, we've established this or these facts, and it is now the proper responsibility and duty of all those who interact with the People's Republic of China to bring that fact into consideration as they make their decisions what to do, what not to do. So that's the sort of theory of people's tribunals, and it's time you heard a bit from Hamid. I met Hamid, by the way, just so that you can understand it all. I'm an ordinary old barrister working away in London, and somehow I got called to work for something called the Iran Tribunal, which is another people's tribunal. And I think this was the first time, I knew about people's tribunals. It's 2014, I think, thereabouts, a bit earlier. And I think it was probably the first time Hamid knew about them either. We both got involved, and Hamid ran the thing really, and I kept as limited a position as I could. So I was able to watch it from some distance. He can perhaps tell you a bit about it. And it, in a way, was one of the most important experiences of my life, because it did show how citizens who see that something needs to be done and get it done can draw benefits of all kinds from, in this case, the tribunal, the Iran tribunal, dealing with something totally different, the massacres in 1980 in the prisons of Iran by the regime of the Ayatollahs. But this is really Hamid's field, not mine.
Many thanks, Jeffrey, and thank you all for attending this, and thank you, Elke, for organizing it. Yes, we met on Iran Tribunal, it was 2010, so time passes very quickly, and we had the hearings in 2012, and the judgment came out in February 2013. It was a massive effort, and it was entirely grassroots because it was organized by political prisoners themselves, and they run everything and use the lawyers as an instrument to achieve the end result, which was a very successful tribunal in my view. China Tribunal, similarly, was a very successful tribunal. We had substantial number of witnesses. The tribunal was composed of 7 members who acted as jurors and not as lawyers and not as judges in that sense. They judged at the end the issue, but in format of a jury. For legal issues, they received advice from senior counsel from different jurisdictions and then made decisions on that basis. The evidence that was submitted to the tribunal consisted of the forced organ harvesting methods that had been in public domain, that run into thousands of pages. Books had been written, articles, and investigations had been carried out by different parliament, different organizations, NGOs. All of them were compiled and handed over to the tribunal, and it was reviewed by every single member of the tribunal in depth. And then we have 29 witnesses of fact and 26 experts that gave evidence in 2 sets of hearings in December 2018 and April 2019. And they set a complete view of what has happened in China and the background of the forced organ harvesting. The tribunal reviewed every single evidence that was submitted to it, and it's all reported in the final judgment, and arrived at its conclusions of fact and then conclusions of law. The issues that were before the tribunal was that huge number of Falun Gong members were kept in sort of concentration camps for the purpose of changing their mind or brainwashing them. But in the meantime, they draw a substantial amount of blood every 3 months from them and examine their organs without ever reporting why these had been done. The evidence from outside China showed that substantial number of organ tourists had traveled to China and received organs within a short period of time. These evidence put together, and the fact that there were military hospitals next to the concentration camps, that the evidence suggested that you could book transplants for heart and other organs that would necessitate that the donor be dead at the time of transplant, way in advance and exactly at the time that was appointed, the transplant took place. It would not be possible to fix a heart transplant 2 weeks in advance because you wouldn't know when you will find a donor. But in China, that was possible. In China, it was possible to get 2 lungs transplanted, a full liver transplanted, and all of this necessitates the donor to be dead. And that could not have been done in advance. So the tribunal came to the conclusion after reviewing all the evidence and also reviewing the Chinese side of the story that they said this is coming from voluntary donors, and there's a list of donors. The tribunal found that there were substantial mistakes and adjustments or fabrication of data on the list of donors, and therefore it had to conclude that they cannot rely on that. They ultimately, tribunal came to the conclusion that there has been a population of donors accessible to hospitals in the PRC whose organs could be extracted according to demand. And this has coincided both with the long-term practice of PRC of forced organ harvesting and many Falun Gong practitioners, along with Uyghurs, being compelled to have medical tests focused on their organs. With this conclusion, the tribunal concluded that since 1999, there has been a consistent use of Falun Gong members as donors or forced organ harvesting donors of the organs, and these have been used by China for its purposes and probably for profit. At the conclusion of the law, the tribunal decided that taken together, such acts of the Chinese state constitute crimes against humanity, and the tribunal was certain beyond doubt that these crimes had been committed. Also, the tribunal found that the Chinese official had committed the crime of torture against their inmates in the camps, and again found that it was certain beyond reasonable doubt that this has occurred. Finally, the tribunal concluded that those who are interacting with China, they are interacting with a criminal state. The decision was finally published in a summary form in June 2019, and the final judgment was published in March 2020 and is available on the website of the China Tribunal and also on Amazon. That is basically the report of this tribunal. Thank you for your time.
Thank you, Hamid. And I hope that you see from what Hamid has explained that in a curious way, the tribunal is a sort of mechanical machine. It doesn't allow anything except evidence to weigh on its thinking. And I'm going to come back to that in a minute. But I just want, before we move on to detail, to say just a couple of other things about background and underlying theory. Duties in respect of wrongdoing in other countries can largely be traced back to the end of the Second World War, to the Universal Declaration of Rights, and indeed specifically, which was 1948, and specifically then to the Genocide Convention, which came a few years later. It's interesting, by the way, to know that that extraordinary document, the 48 Declaration, that could never be written now, people would never agree to as much, was the masterpiece of Eleanor Roosevelt, was initially drafted by a three-man tribunal, one of whom was a Chinese Confucian philosopher. How is the world changed? But there you have the statement in 1948 of what are called universal human rights. Whether they really are universal in the sense of being imbued into a human being wherever that human being is born at birth, or whether they are rights that it was judged after 2 terrible wars, it was critical to say were universal, doesn't necessarily much matter. But it is they that lie behind much of what has happened in the development of international criminal law ever since. And it does seem to me that it is unstated sometimes, that where that developing concept of rights has come about, how it's come about, how it's grown, means that the rights and the duties that arise under or as a result of the rights, you have a right, I have a duty to respect your right. The duty is the duty of the citizen, not of the government. Each citizen owes to each other citizen the duty of respecting his right to life, her right to life, her right to the various freedoms advanced in the 48 Declaration. Of course, and for the most part, citizens can only ever do that through the agency of either their elected or appointed government. It doesn't stop the duty still being my duty to respect your rights, and in certain circumstances, maybe to do what one can to respect your rights. And you'll find at the end of the judgment of the tribunal, which by the way is available on the first page of the China Tribunal, you can just open it up and print it, or you can find the thing, I think, on Amazon. It now looks that big, but it's only the first 100 and something or other pages, 170 pages that are the judgment. The rest of it's some of the evidence, and the rest of the evidence, all the evidence you can find on the website. Because at the end of the judgment, we turn very briefly and sort of in passing to what, for example, the shopper can do to reflect the rights of others by boycotting, as it used to be called, still is called, goods provided by a wrongdoing state. It's happened off and on around the world, sometimes with limited success. And I believe I may be speaking to some people in America, hope so. And if I am, you'll be pleased to know that I think the first recorded example of boycotting of goods was of by the Americans of British goods. So there we are. But it's always, but we mention that as something that the citizen could do, armed with the information that we provided. In any case, so those are a couple of things for you to think about, maybe. Coming back to the detail of what Hamid has told you, and just to expand on a couple of points, 3, I think, really. First, although we happen to have lawyers sitting on the tribunal, there was me and 3 others from 3 different jurisdictions, one American, one Iranian, and one Malaysian. We all 4 ceased to be lawyers. We were just citizens, and we simply waited to be told what the law was, effectively by a judge, but because it wasn't a judge, it was a legal expert. Why did we do that? Why did we think that was important? Well, logically, if the world citizen has been failed because governments and international bodies full of experts, lawyers, politicians, NGO bodies full of the same, if they don't deliver, why should we, in doing what they haven't done, sort of ape their procedures? No, we shouldn't. We should say, okay, well, that system didn't work, hasn't worked, at least not in this problem. And so let's see what we can do. As citizens, we applied a few essential, readily understandable procedural parameters of the kind that you will find in courts to ensure that the process was fair. setting the very high standard, proof beyond reasonable doubt, trying to find every piece of evidence that would favor the People's Republic of China, and listening to it and arguing it. And in that regard, I can't remember now if Hamid told you this, but we wrote to everyone who'd said anything favorable to China, still alive, about these practices and asked them to contribute. They didn't. We wrote to the People's Republic of China, inviting them to attend the hearings, to give evidence, to do everything they wanted. They didn't even acknowledge the many letters that were delivered at their premises. So that's another general principle applicable to law that, of course, we applied. To give you an example of how far we went in that, in order to hear the other side, a principle of natural justice, there was one report in Australia of a subcommittee in 2018 where the People's Republic of China had more or less said something about its approach to human rights and these things. And so we extracted from that everything that we could that was arguably favorable, that had been said by the People's Republic or by one or two doctors speaking on their behalf, and analyzed that. And another way in which we tried to deal with this problem was that our own government, the British government, doing what I'm afraid governments do all the time, when asked, well, why aren't you doing something about forced organ harvesting? Here's the evidence. And it wasn't just us. I mean, we were at work, but very, very authoritative bodies have been reporting on this for well over 1 decade, nearly into 2. And the government would always reply through a minister some weaselly words along the lines of, well, we're not quite sure about the evidence. And so people in the House of Commons and the House of Lords, our 2 chambers in England and Wales, and Scotland still, would ask more and more questions, and the position of the government would sort of slowly change. And eventually they were driven to say such things as, well, our analysis of the position is that the evidence isn't quite enough. Of course, they didn't want it to be quite enough because they had all sorts of interests to serve, commercial. Our assessment of the evidence is not quite enough. And so, of course, we wrote to them and said, gosh, how interesting. You've done an analysis. Please let us have it. Come and give evidence about it. You can be the last witness in the case if you like, or in the hearings if you like. Tell us all that's wrong with our analysis. Please come. Of course, they didn't. Although now the matter's been dealt with much more regularly in Parliament, and the government is finding it very hard indeed now to deny the accuracy of our judgment, and more or less never does so. So there we are, a couple of things. Why we have ordinary non-lawyer, non-specialist citizens, how we try and respect fairness principles, and one other thing, and then I think it's probably almost time to throw it open to questions and answers. 2 other things. The first is this: how do we set aside if we have prejudged opinions about the People's Republic of China being a human rights violation? And we did have those opinions. It would be impossible not to have them, and it would be dishonest to say we didn't have them. We acknowledged straight away, yes, we had read we had read nothing, any of us actually, about forced organ harvesting or the Falun Gong. We were complete newcomers to that. But of course, we'd all read about the People's Republic of China being a massive human rights offender. So we set it up right at the beginning. Yes, we recognize that. How are you going to set it aside? Well, what we did was the following. We took the evidence and we broke it up, and it was evidence that could conveniently be broken up because it came in different categories. Let me just give you 2 categories, I suppose. One category is of people in custody, Falun Gong and others, but people in custody and their treatment. Well, treatment was torture and all sorts of other things. But the Falun Gong in particular, and almost no one else, were really tested by blood samples and by other methods in ways that were consistent with checking on the state of their organs, nothing else. And by the way, of course, the Falun Gong, peaceful people, don't smoke, don't drink, pretty healthy, good organs. And so we took that evidence, just the evidence of the medical testing, and we said, okay, got this evidence. Now let's say, what would that evidence tell us if it related not to the People's Republic of China, but to, say, New Zealand or the Republic of Ireland, countries which both have very good human rights records? What would it tell us just on its own? And so we reached a little decision. We then turned to the next category of evidence. We did the same thing. So another category of evidence would be evidence of phone calls. Phone calls have been made by people very concerned about these practices for a decade and more, hundreds of thousands of them, to hospitals and medical practitioners in the People's Republic of China. Of course, the phone calls are designed to trick, but that doesn't matter. Deception is as old as the art of detection. Sometimes you have to engage in trickery. Although, of course, if trickery is involved in this kind of way, you've got to allow for the risk of its polluting the evidence. But nevertheless, so somebody rings up and says, I'd like a liver because my relation, my spouse, my auntie, my mother, my father is in need of a liver. And can you provide one? So the answer would come back, yes. And when? Well, next week. And if you keep getting that evidence, and the phone calls provided that evidence on a massive scale, you're able to draw, and about other organs as well, kidneys and so on and so forth, you're able to draw conclusions, not in respect to the People's Republic of China, but in respect of such evidence applied to another imaginary country, or if you find it easier, a country you know to be a country of good repute. Then you have a series of small, always very conservative decisions. You add them together, out comes the result. And you'll find all that set out in the judgment. And for those of you who are interested, there are two ways of looking at the judgment. Obviously, you can get it from Amazon for, I don't know, whatever it is, not very much. But you can also just view it online. And if you're interested in particular in the general approach of people's tribunals to decide yourselves whether they are things that can be of value, then you only need to look at the first 25 pages, the first 126 paragraphs and 25 pages, but read the introduction as well. That sets the scene. And you can also look at all the individual categories of evidence, which are well indexed. And then if you're really interested, you can go deep into the evidence itself. I should think that's probably enough from me. Hamid seems to have decided to close himself down. Now he's back. So unless I've missed anything obvious to Elke or to Hamid, I suggest we throw it open to questions. And so far, there's one, two. And there we are.